Today we are looking at a really landmark Supreme Court case, Lalita Kumari versus the government of UP. And our mission here is to figure out if the police actually have a statutory right to just refuse your FIR.
Yeah, and to get to that answer, we really have to start with the human struggle behind it. I mean, think back to May 2008. Bola Kamat's minor daughter, Lalita Kumari, was kidnapped. And when he rushed to his local police station in an absolute panic, the officer in charge just flat out refused to register his complaint.
Right, which is terrifying. And even after he finally got the superintendent of police to register it, the police took zero action to find her. So that total systemic paralysis forced him to file a writ petition for habeas corpus under Article 32, pleading with the Supreme Court to step in.
Exactly. And it really makes you wonder how local officers were justifying that initial refusal under the Criminal Procedure Code. They were basically exploiting this historical ambiguity around Section 154.
Because the big debate was whether Section 154 gives police the discretion to verify if a complaint is true before writing it down, or if recording it is just an immediate mandatory duty.
Right. And the state governments were defending what we call the burking of crime. So burying cases to artificially suppress their official crime statistics. But they used some heavy legal gymnastics to justify it.
Yeah, they argued that if they instantly registered every single complaint without any filter, it would lead to all these frivolous FIRs, which would harass innocent people and violate their Article 21 rights to life and liberty.
It was a really clever defense, honestly, framing the refusal not as administrative laziness, but as this necessary shield for civil liberties. So the Supreme Court actually had to form a 5-judge Constitution bench to untangle this exact tension.
And it is incredible how decades of police practice got completely dismantled by a strict, literal reading of just one single word in Section 154, the word shall.
Yes. The statute literally says the information shall be reduced to writing. The court looked at that and determined the legislature just did not leave any room for interpretation there.
Meaning, if the information you give them discloses a cognizable offense, basically a serious crime FIR registration, is absolute. The police are totally stripped of the power to judge your credibility at the doorstep.
They have to register first and investigate later. And to handle that Article 21 argument from the states, the court drew a really hard line between registering an FIR and actually arresting someone.
Because filing the FIR just starts the documentation.
Exactly. The safeguards against arbitrary arrest are still totally intact under Section 41. The court's point was you don't block a victim's FIR just to protect an accused person's liberty.
You separate the two. You document the grievance immediately, but throwing someone in jail requires its own distinct legal justification.
Precisely. But the court did carve out a preliminary inquiry exception.
Which sounds like a massive loophole. Like, what stops an officer from just burying your complaint in a month-long inquiry and saying they're just screening it?
Well, the court anticipated that. So the preliminary inquiry is restricted to very specific categories. We are talking matrimonial and family disputes, commercial offenses, medical negligence, corruption cases.
And cases with abnormal reporting delays, right? Like if you wait 3 months without any explanation.
Right. And even in those specific cases, the police are on a very strict 7-day clock.
And the purpose of that inquiry is only to determine if a cognizable offense actually exists.
Yeah.
It is not to verify the facts of the case or test if you're telling the truth.
Correct. Every minute of that delay has to go into the general diary. So the scope is incredibly narrow by design to ensure this exception doesn't just swallow the rule of mandatory registration.
So the directive for you listening is clear. The police cannot legally turn you away for serious crimes. If they do, you mail the superintendent of police.
And for the legal professionals tuning in, your job is to strictly monitor that 7-day limit on preliminary inquiries to make sure the system isn't just stalling out your clients.
It all comes down to the court emphasizing that an FIR does not equal instant arrest, because that fear was weaponized to block victims from justice.
Right, which leaves you with a really provocative question to mull over. If the terror of an FIR is largely tied to a misunderstanding of what it actually triggers, how many other vital legal protections are we simply ignoring because we misinterpret the very first step of the process?